All right, hello everybody. This topic is just all out nuts. Man, usually I'm just ready to roll on all these live streams that I've done. Not a whole lot of preparation necessary, just because I've answered so many questions over and over and over again, and I'm just answering some questions here. But this one's a little bit different. Let me get myself straight here. Excuse me for a second. Yep. Let's see. Okay, so yeah, this is all about the IRA beneficiary designations and all the rules, Secure Act, 10-year rule, life expectancy, eligible designated beneficiaries. We got a whole bunch of terms, and I kind of struggled with how to organize this content in a way to present it to people to make it relatively easy to understand. So the way I'm going to tackle it is I'm just going to start with just a few minutes of here's some terms that you're going to hear over and over and over again. So let me just introduce you to these terms. But then really, I think the best way for me to apply the rules to you is give you some case studies, some scenarios. Okay, here's a marriage, one marriage, children of the one marriage. Or here's a single person who has adult children. Here's a single person who has minor children. Here's where if you're married, but maybe you had children from a prior relationship. So how does that work? What should you do with your IRA there? So I think you'll get the most out of this when we get in just a few minutes to the various scenarios. And I'll talk about some of the pros and cons about how you should leave things and what are some of the rules that apply. So I have to admit, a couple of people have commented, not many, one or two have commented on my live streams that they find some of my material a little bit repetitive. I'm going to tell you right out front, there's going to be times where I'm going to be repeating myself throughout the live stream here, because these rules are complex, and I know that unless you're brilliant, you have to hear it 2, 3, 4, 5, 6 times before it really catches on. So you'll hear some things multiple times. I'm going to try to balance, hearing it once versus hearing it several times and how that might affect you. You're likely to get a little confused. I'm going to be using a bunch of Internal Revenue Code terms that you don't use every day. So, but the good news is, if you have a set of circumstances and maybe it's a little bit unique, we know where to look for the rules. We might have to dig deep to find our answer in the rules, but there are rules that exist. Hey, everybody, good to see you. I'm seeing some chat here on the sideline here. So we got all of our usuals: Larry, Shane, Susie, Todd is a new one, I think. Good. Thanks, Todd. We got Missouri, Arizona. We got so much stuff. Okay, so just as we do every time, I'm going to present some information for a little while, and then we'll go over to the chat. If you've got an experience, comment, question, feel free to throw it in there. I don't know if I'll be able to answer every question because there's a million different scenarios, so many different rules that apply, but I'm going to do my best. But I would say don't, this isn't kind of attorney-client legal advice. No attorney-client relationship is being established here. So, take the information with a grain of salt. I'm just trying to share some terms with you and share some knowledge. So, all right. I also want to say that I've had a number of clients. We have a national estate planning law firm. We help people all over the country with, it comes through our office. We get things reviewed by our co-counsel in the different states. So I've had a number of people come to me and tell me something like, Paul, I have these special issues with my IRA, or they might tell me, Paul, my IRA is the largest asset I've got in value. Yeah, I've got a home worth $600,000, and yeah, I've got a few shares of stock outside of my retirement accounts that are worth $200,000, but Paul, my IRA is worth $1.5 million. And so, that's maybe the most important piece of my estate planning that I need to get right. And some people will say, well, Paul, I went to this one attorney and they either said that they didn't understand all of the rules that apply to distributions from IRAs, or some attorneys out there will say, well, yeah, I'm an estate planning attorney, but I don't handle anything that's tax related. To me, that's a little bit of a cop-out. So much of estate planning is tax related, between income tax, capital gains tax, Federal and state estate tax, gift tax, especially when it comes to IRAs and the income tax, the step up in basis on other assets outside of retirement accounts. So to say, if you go to work with someone who's an estate planning attorney to get your stuff straight, and they quickly kind of tell you, look, I can prepare your will or trust in your power of attorney, but I'm not well versed in taxes, or I just don't deal with the taxes. That's again a little bit of a cop out. You may want to look for someone who at least has an understanding of the tax rules. Not to toot my own horn, but after law school, went to Boston University for a year, master's in tax law. That's not even really what gave me the tax knowledge. What gave me what tax knowledge that I have is dealing with people for 30 years and them asking me questions that had a significant impact on what people will inherit, how much they'll have to inherit, how much goes to the government. And so with each client, I've had to dig in to provide answers. So anyway, just wanted to start with that. All right, now I'm going to just give you some terms that you're going to hear, but just know that we're going to talk through some scenarios, which I think will be more helpful than the terms, but I feel like we've got to start with some terms. I also want to start with the very basics of, hey guys, those IRAs, and again, just maybe this isn't you, but I've dealt with many, many, many people, and their IRA is their largest asset because they built up their 401k while they were working. They retired, they rolled their 401k over into an IRA. That's where their big money is. And their big money might be $400,000. It might be $4 million, but that's where most of their investments are held inside of their IRA or their 401k or their retirement account. Yes, many people also have other investments outside of their retirement account, or they have savings accounts or CDs or brokerage accounts that aren't retirement accounts. But really, IRAs are a big deal for middle to middle upper class, America these days. So we gotta start becoming familiar with some of the terms that relate to IRAs. But what you really need to be aware of at its most basic level is if you do own a 401k or an IRA, I'm going to use IRA primarily, but all these rules that apply to IRAs, they also apply to 401ks, and know that there are traditional IRAs and there are Roth IRAs. Typically, traditional IRAs, the income tax hasn't been paid yet. It gets paid when it comes out of the IRA, subject to rules that we'll talk about. Roth IRAs are created with after income tax funds, and so they come out income tax free, and that has a big impact on how you should set things up. So, if you can't say in your will, I leave 100% of my IRA to Cindy, where if on your IRA beneficiary designation form you named Fred as the beneficiary, even though in your will you said, I want my IRA to go to Cindy, that really provision in your will is meaningless because it's all about the beneficiary designation. So setting up the beneficiary designations on your IRAs and 401ks is really critical. A lot of times the lawyers should be involved in the designation of the beneficiaries on the financial firm's beneficiary designation form. So sometimes it's just necessary to make the beneficiaries consistent with the overall estate plan. Also know that sometimes people don't designate beneficiaries. And when they don't designate beneficiaries, it doesn't necessarily mean that it gets payable to their estate, which is not a great thing for a lot of reasons that I'll talk about during this live stream. Sometimes, I've had it many times where dad died and, he set up his IRA or his 401k 20 years ago and he didn't designate beneficiaries. Or maybe he designated his spouse and his spouse, already passed away. So there are no beneficiaries. A lot of IRA contracts, a lot of 401k, plan agreements have default rules. Okay, so the IRA owner died and they didn't designate any beneficiaries. You have to look to the terms of the IRA agreement because sometimes they'll say, well, if there's a spouse, pay it to the spouse. If there's not a spouse and there's children, then the IRA goes to the children under these default rules when there were no designated beneficiaries. So you have to look at all of that either during your lifetime or when an IRA owner passes away. All right, let's get into some of these terms. I'm going to try not to use the term eligible designated beneficiary too much because it other than spouse, it doesn't apply very much. But we're going to talk about a 10-year rule here in a moment. But if you have an IRA and you name an eligible designated beneficiary, then that creates an exception to the 10-year rule that we haven't talked about yet, but we will talk about in a moment. So there's 5 categories of eligible designated beneficiaries that get more preferential income tax treatment after the IRA owner dies. So one type of eligible designated beneficiary is a surviving spouse of the IRA owner. A lot more on the surviving spouse in a minute, but let me go through these eligible designated beneficiaries. As I repeat myself, this is an exception to the 10-year rule that we're about to talk about. A child who has not yet reached the age of 21, if you have an IRA, you pass away, and you leave your IRA to a child who isn't 21 yet, they are an eligible designated beneficiary. Some complicated rules apply there. The next category of eligible designated beneficiaries is the disabled. So here's where we're getting into some categories that you don't see much, but nonetheless, a disabled beneficiary, if that beneficiary is over 18 at the time they become a beneficiary when an IRA owner dies, they're disabled if they're unable to engage in substantial gainful activity. If they're under 18, they're disabled if they have this severe functional limitation. If they are determined disabled for Social Security, then they'll also be determined disabled for purposes of being an eligible designated beneficiary. Hint, by the way, they get to take required distributions over their remaining life expectancy instead of having to take the money out and pay income tax within 10 years after they pass away. More on the 10-year rule in a minute. A fourth out of 5 category of eligible designated beneficiary, I don't think we're going to see this much, is the chronically ill. They also get to use their life expectancy for purposes of taking required minimum distributions when they're the beneficiary of an IRA. A chronically ill beneficiary is one who's unable to perform at least 2 activities of daily living: mobility, dressing, eating, personal hygiene, and toileting. So again, if you have a beneficiary who's chronically ill, they don't have to take it all out and pay income tax within 10 years. And another happens to use the number 10, but it's an exception to the 10-year rule. If you have a beneficiary who's not more than 10 years younger than the IRA owner. So if you're 72 and you leave your IRA to your brother who's 68, they're not going to be subject to the 10-year rule that I'm going to talk about next. They can take distributions over their life expectancy. Okay, so I wanted to just get those 5 categories of eligible designated beneficiaries. Let's get them out of the way. And but there's, in virtually every article or summary of Secure Act 2.0, you're going to read a lot about eligible designated beneficiaries, and that's okay. We introduced you to them. Now I want to talk about what is more common, other than surviving spouse, is just the qualified designated beneficiary. These aren't eligible designated beneficiaries. These are what's called qualified designated beneficiaries. They are subject to the 10-year rule, or the IRA owner dies, they leave their IRA to one or more qualified designated beneficiaries. So dad dies, he has 2 children, one who's 50, one who's 45. Those are the 50-50 beneficiaries. They're qualified designated beneficiaries. They don't fit under any of the eligible designated beneficiary classifications. They're not disabled. They're not chronically ill. They're not more than 10 years younger than the owner, and they're not a surviving spouse. So, so they qualify as a qualified designated beneficiary. And so we'll talk at length in this live stream about how qualified designated beneficiaries, children who aren't minors, are adult children are typical qualified designated beneficiaries. They must take a full distribution by the end of the calendar year that includes the 10th anniversary of the IRA owner's death. So, dad dies. He's in 2024. Sure, those qualified designated beneficiaries, if they want to take all of the money out and pay income tax on it immediately, they can, but they don't have to. They can wait until 2034 to pull the money out of that inherited IRA and pay income tax, but they got to pull it all out within 10 years after the IRA owner dies if they're a qualified designated beneficiary. Now, a qualified designated beneficiary must be either an individual, like a child of the parent, and the child's 45 or 50, we said, or a qualified designated beneficiary can be an identifiable beneficiary of a see-through trust. Don't throw your hands up just yet. A lot of IRA owners like the concept of naming a trust, for example, for their children as the beneficiary of the IRA. Why would they want to do that? It's not so much an income tax savings mechanism. It's typically more of the, I'm scared my beneficiary is just going to take all the money out immediately and blow it. So trusts are the most common reason people use trusts as beneficiaries of IRA, is to provide for some kind of ongoing management of the IRA funds after the IRA owner dies, so that the beneficiary doesn't blow it all in one big chunk. So if I mentioned a qualified designated beneficiary, let's say, the 60-year-old dad has $1 million IRA, and let's keep it simple, he has one child who's 27 years old, but whenever the 27-year-old gets a nickel, he spends a quarter. So, geez, dad's like, if I just name my son as the beneficiary, he could wait if he wanted 10 years after I die to take out all the funds and pay the tax, but he ain't going to wait 10 years. He's going to cash it all out immediately, and hopefully he'll pay the tax, but he's going to go spend it all. So he says, he's like, I don't want him to do that. I'm going to leave it to a trust. Now, if you're going to leave an IRA to a trust for an individual, 100% of the time, you're going to want to make sure that trust is a see-through trust. Sometimes people call it a qualified trust. I call it a see-through trust. I've heard it called a look-through trust. It's pretty easy to meet the requirements of a see-through trust. 60-year-old dad, going to leave his $1 million IRA, 27-year-old son, doesn't want the son to have the ability to just cash it all in and go blow it the day after dad dies. So he says, I'm going to leave it to a trust, but I hear I need to make it a see-through trust. Well, there's 4 requirements that have to be met for a trust to be considered a see-through trust. And if it's not a see-through trust, then the tax has to be paid much quicker than 10 years, because you have to pay the tax under the when a trust is a beneficiary of an IRA rule. But when you leave it to a see-through trust for the son, you can look through or see through the trust and know that the son is a qualified designated beneficiary, and thus the taxes don't have to be paid until 10 years after IRA owner passes away. So to meet the requirements of a see-through trust, number 1, trust must be valid under state law. Pretty easy to meet that one. Number 2, trust must be irrevocable upon the IRA owner's death. Also not difficult to meet. So many people who create trusts, some people create irrevocable trusts, and they're irrevocable from the moment those trusts are created. Other people create trusts who, upon the death of the person who created the trust, that trust becomes irrevocable. So that's common, and that meets this second requirement. The third requirement to meet a see-through trust is all beneficiaries must be identifiable. So, for example, 60-year-old dad sets up a see-through trust for 27-year-old son who spends a quarter every time he gets a nickel. It's going to be identifiable in the trust instrument that the son is the beneficiary of that trust. So no problem meeting that requirement. And the fourth requirement of a see-through trust is that documentation of the see-through trust must be provided to the IRA custodian by October 31st of the year following the IRA owner's death. Typically not a problem to meet that one either. So we're going to just shove all of this see-through trust stuff aside. I'm not going to talk too much more about see-through trusts because it is fairly easy to meet the requirements of a see-through trust. And again, the reason you want to do that is because a qualified designated beneficiary can take advantage of waiting 10 years to pay the tax after the IRA owner's death. And a qualified designated beneficiary must be either an individual or an identifiable beneficiary of a see-through trust. Okay, now still on the trust thing, and we're about to get to some scenarios here where we'll put it all together, but I gotta introduce you to some terms that I'll be repeating over and over again. When you do name a trust as a beneficiary, well, the trust is going to be either a conduit trust or it's going to be an accumulation trust. More on that in a bit. Conduit trusts are such that the trustee of that trust must immediately distribute all available income and principal to the beneficiaries. And an accumulation trust allows the trustee to accumulate these benefits. Now, stay with me. Conduit trust, let me just throw this out there. We can come back to it later. Conduit trusts are typically best for minimizing income tax because assets aren't accumulated in the trust. They're distributed to the beneficiary. And so conduit trusts don't have to pay tax at the higher trust income tax rates. So conduit trusts are great for minimizing the income tax and having all distributions payable at an individual's income tax rate instead of the higher trust income tax rate. But conduit trusts aren't great for preserving the money over the lifetime of a child, for example. Accumulation trusts are good for preserving the money over the lifetime of a child, but not good for minimizing income tax because accumulation trusts are accumulating distributions in the trust and likely 37% income tax is going to be paid. So more on that later. But I will mention this one a couple of times. Maybe one of the most important things I say in this live stream is there's many people out there, maybe married people who are in a blended family situation, or maybe people who have children and they don't like the fact that the children can get the money immediately after the IRA owner dies and don't even like the fact that they could get it within 10 years after the IRA owner dies. Those IRA owners should be considering converting traditional IRAs to Roth IRAs, because if you're going to leave assets to what I'll call an accumulation trust, you want those assets left to the accumulation trust to be accumulated over time. You want those to be Roth assets because it's Roth that comes out tax-free. And then even though the assets are accumulated in a trust, there's no income tax paid on a Roth distribution. More on that later, but just keep in mind, we're going to be talking a little bit about there are some circumstances where it may be better for mom and dad to start converting to a Roth now because the income tax at the mom and dad level will be significantly less than the income tax at the 37% trust level when assets are left to an accumulation trust. Wow. Okay. So I'm done just giving you a bunch of terms. What I want to do now is let's jump into some scenarios. Make sure you like, subscribe, all that good stuff. So our first, and I'm going to start with the ones that I feel like are most common. Sure, we got a whole set of a bunch of complex rules, but I really want to start with the basics, the most common scenarios, rather than talk about all of this esoteric rules that only apply maybe 0.001% of the time. All right, so our first scenario is what I think is the most typical scenario. You've got a married couple, one marriage for each spouse, and they've got some kids. And if they're trying to figure out how best to designate their beneficiaries on their IRA, let's say they've got adult kids. Most people, when they're getting serious about this stuff, they're approaching retirement. They just retired. And so most of these people who are getting serious about how to leave their IRAs, their kids are adults. Their kids are over 18. Their kids are 20s, 30s, maybe even 40s. So that's the typical scenario, an older couple with some adult kids. Also, most of the people who have large IRAs are older, quite frankly, because they contributed to those 401ks, a little at a time, paycheck after paycheck, month after month, year after year, perhaps for decades. And it took that compounding to reach the $1 million 401k, the $2 million 401k. That typically doesn't get done overnight. Rarely do I find a 30-year-old who has a $3 million IRA, but it's not uncommon to find a 70-year-old with a $3 million IRA because he's been putting it aside regularly, dollar cost averaging, and compounding for decades. So as a result, typical scenario, you got a married couple, kids, adult kids. Typical scenario, let's say there's two kids. And let's say the husband has the IRA, and in a lot of these examples, I'll say the husband dies first, but it really doesn't matter who dies first. But just to keep it consistent, husband was the employee, husband socked it away in his 401k, husband retired, rolled it over into an IRA. It's in the husband's name. He's got a wife and kids. 95% of the time, he's going to say, I'm going to name my wife as my primary beneficiary, and I'm going to name my two kids as the contingent beneficiaries. So that's okay. That's, in most cases, that works. And then when the IRA owner dies, the surviving spouse has a decision to make. Although I'll be quick to say here, even though the surviving spouse has options, when the first spouse or the IRA owner spouse dies, the surviving spouse often never gets to exercise those options, often because the financial services firm will say, oh, Mrs. So-and-so, Mrs. Flintstone, I'm so sorry to hear your husband, Mr. Fred Flintstone, died. Yeah, he has this $1.4 million IRA. We got to get it rolled over into your name. Come on by, sign some forms. We'll get that rolled over into your name, and it'll be treated as your IRA, which does happen most of the time. And in most of the time, that's the right thing to happen. But occasionally it's not what's best for the family. But once that IRA gets rolled over into surviving wife's name, then she just lost all options to perhaps treat it as something different. So let's talk about that for a minute. Because what that surviving spouse has to consider is not only the income tax aspects of inheriting an IRA from her husband, but also the estate tax, both federal and state. And sometimes the surviving spouse has to even consider the surviving spouse's potential future Medicaid eligibility if they're going to have to go into a nursing home. So again, my caution to you here is, if your spouse died and they had a big IRA, maybe just time out, even though the financial services firm is saying, come on in, sign the forms, we'll roll it over to you. May just want to make sure you make an informed decision before you do roll it over and lose the opportunity to do other things. So for example, if that surviving spouse is under 59 and a half and needs the funds to live off of, it may be better for the surviving spouse to treat that as an inherited IRA rather than rolling that IRA over into her name and treating it as her own. It may be better for that surviving spouse to treat it as an inherited IRA so they can take distributions prior to age 59 and a half without incurring the 10% penalty. Because what happens most of the time is dad dies, he has his $1 million IRA, his wife is 52 years old, he died. Of course, hey, let's roll it over. And so she does one of these spousal rollovers. Now that IRA is in her name, she treats it as her own. But because she did a spousal rollover and she does treat it as her own, it's her IRA to do whatever she wants to with, which is great, everybody's thinking. But now she needs money. And if she's got to take out money prior to age 59 and a half, she'll get a 10% penalty. And maybe she's okay doing that. But sometimes it's better for the surviving spouse to treat it differently, not roll it over into an IRA in their name, but to treat it as an inherited IRA so they can take distributions prior to 59 and a half. I will say, however, that an IRA owner, their IRA is protected, is better protected from creditors of the surviving spouse if they do roll it over into an IRA in their name. So there's that to consider. But another thing to consider is what are the estate tax, both federal and state estate tax consequences to this. So we know, if you've been around and listened to some live streams, we know we have this big $13.61 million federal estate tax exemption. And we have this opportunity when the first spouse dies for an estate tax return to be filed and a portability election to be made, so that the unused $13.61 million exemption of the first spouse to die gets added to the exemption of the surviving spouse. So here's a case where, let's say dad died, he had a $4 million IRA, named his wife as the beneficiary. She rolls it over into an IRA in her name, which is great. It's all part of her estate, but it's, when she gets this $4 million IRA and her estate tax exemption falls back to around $7 million in 2026, because that's when the Tax Cuts and Jobs Act requires that this sunset cut the estate tax exemption in half. If she's inheriting a large IRA, certainly would make a whole lot of sense for her to file a IRS Form 706 federal estate tax return after her husband died, so that his unused estate tax exemption, he didn't use much, if any, of his estate tax exemption, because he took advantage of the marital deduction by leaving his estate to his wife or his IRA to his wife. So in fact, this is a good general rule. If your spouse dies anytime prior to January 1, 2026, then you need to take a look and find out if filing an estate tax return and making the portability election makes sense. So yes, will there be an expense in filing the return? Yes, there will be. But to be able to take up to $13.6 million of an exemption and add it to your exemption, that can be really, really valuable, can save millions of dollars when the surviving spouse passes away. Now, here's another reason why, for some, why they shouldn't just automatically roll over the deceased spouse's IRA into their own IRA. Perhaps you live in a state where there is state estate tax and your state doesn't allow for portability. Sometimes it's appropriate, and let's say your state has a $2 million state estate tax exemption. Sometimes it would be appropriate for the surviving spouse to disclaim or refuse some of their spouse's IRA to allow their spouse's estate to fully utilize their $2 million or whatever it might be state estate tax exemption. So if husband dies, he's leaving his $4 million IRA to his wife. He has another $1 million of assets between his home and other assets, and he uses $1 million of his $2 million state estate tax exemption, but the other $1 million didn't get used. So the surviving wife could, and she's got to do this before she rolls it over into her name, she can disclaim $1 million of his $4 million IRA, let that go to the contingent beneficiaries, probably the kids. She takes $3 million. And now she has a lesser estate that would be subject to state estate tax when she dies because her husband uses $2 million exemption. All right. So really, I'm not asking you to memorize all of what I'm saying here. There's no way. Just what I'm hoping we're doing here is we're realizing that, hey, when somebody dies, there might be some things we have to look at before we start taking action, signing forms, and moving money around. All right, here's another one. So the traditional, this is for the people who don't have a lot of assets. I know we've had some comments of people say, Paul, you give great advice for people with this $13.61 million estate tax exemption. That's great, but it'll never apply to me. I hope to contact you when I win the lottery. What I'm about to say, it doesn't apply to the people with millions of dollars. It applies to people perhaps with hundreds of thousands of dollars. So one of the things we see sometimes is Sometimes you'll have an IRA owner, and let's say he has a $400,000 IRA, and his wife doesn't have an IRA. He worked wherever and saved, and now he has a $400,000 IRA. His wife doesn't have one, and the family's worried. Family has a couple of kids. Everybody's good. Everybody's responsible. Everybody's adult. Everybody wants what's best for the parents. And so here's a situation where the family's worried because if dad dies, dad's been taking care of mom. And if dad dies, it's likely that mom may have to move into a nursing home. Yes, would it be great if she doesn't have to move into a nursing home? Yes, would it be great if the kids took her in? Yes, would it be great if everybody chipped in where she wouldn't have to go to a nursing home? Of course, all that's fantastic. But nursing homes are full for a reason. But there is a situation where sometimes it's one marriage, adult kids. Maybe it's best for dad to name his children as the primary beneficiaries of his IRA. So he dies, that $400,000 goes to the children. Yes, they'll have to pay the income tax within 10 years after dad dies. But now that $400,000 IRA doesn't get lumped into mom's estate, where she lives in a state where the IRA is a countable resource. So she doesn't qualify for Medicaid until she takes the money out of the IRA, pays the tax, spends all the money on her care, gets down to less than $2,000 before she qualifies for Medicaid. So there is some special situations where if it looks like the surviving spouse may have to go into a nursing home, sometimes it is best for the IRA owner to name the children as the primary beneficiaries, assuming those children are mature, responsible, will set the money aside, will take care of mom. So because we're looking at all of these beneficiary designations in light of both income tax, estate tax, and Medicaid eligibility purposes, this is one where you've got to be informed even before you die and as your designated beneficiaries on your retirement accounts. All right, so good stuff there. That's the married people, one marriage, couple of adult kids, everybody's cooperative. Most of the times it works out fine. Spouse is primary beneficiary, kids are contingent beneficiaries. IRA owner dies, spouse will roll over, spouse can treat it as their own IRA. They then name the kids as beneficiaries. Surviving spouse dies, leaves it to the kids. Kids have 10 years within which to take those required distributions. So as I talk about that, let me go into the second scenario of an unmarried person with adult kids. So it's hard for me to really get this to where everybody understands it. What I just talked about was the options when you had a married IRA owner and they named their spouse as their primary beneficiary. Yes, they likely named their children as the contingent beneficiaries. So what I'm going to talk about next, a single person with adult children, also applies if you have a married person naming their spouse as their beneficiary, their children as their contingent beneficiaries, but their spouse predeceases the IRA owner. Then it's going to go to those children as the beneficiaries when the IRA owner dies. So here's, we just talked about a married person, one marriage, all good, named spouse primary. They roll it over. And there's some exceptions where maybe they shouldn't if the surviving spouse is under 59 and a half and needs the money. If maybe the surviving spouse may need to disclaim a portion of it for state estate tax purposes to use the exemption. Maybe for the surviving spouse's Medicaid eligibility, if they need to go into a nursing home, they shouldn't be a beneficiary. Or maybe next best thing, they are a beneficiary, but maybe they should disclaim it. I know in many states, a disclaimer is treated as if they received the IRA and then gave it to the kids, creating this 5-year look-back period. But if the IRA owner names the children as the primary beneficiaries, you're not going to get a look-back period when the IRA owner dies, leaves that IRA to the kids. If that surviving spouse, if their remaining assets would render them eligible for Medicaid, that $400,000 IRA would be protected. Now we're going to go to the single person with adult kids. I think I need to take a breath every once in a while. I'm seeing some chat. I haven't been able to glance at it, but keep it coming. All right, children as beneficiaries. Here, the rule on what distributions the children are required to take depends on whether the parent, the IRA owner, died before their required beginning date, that date where they were required to take distributions, which is changing now from 71 to 72 to 73. In the future, it's going to be 75. Or did that IRA owner die after their required beginning date, the date that they were required to take minimum distributions? If that IRA owner who names their two children, let's say, as beneficiaries of their IRA owner, let's say that IRA owner is 60 and dies, leaving the IRA to their two children who are 25 and 30. Well, because that IRA owner died before their required beginning date, they were 60, then the children, no required minimum distributions are required during the 10-year period after the IRA owner dies. But at the end of that 10-year period, the distribution from the inherited IRA must be made. And so you've got no required distributions during the 10-year period after the parent IRA owner died, but then it's all got to come out at the end of the 10-year period. Yes, the children could take it out faster if they wanted to, but if there's anything left in there at the end of the 10-year period, it's got to come out and the kids have to pay income tax on that. Of course, these are all, traditional IRA rules. We're going to get to Roths in a bit, but traditional IRAs are the ones that get whacked with income tax. However, if the IRA owner is 80 when the IRA owner died and had kids who were 55 and 45, because the IRA owner died after their required beginning date, then the kids must take required minimum distributions during the 10-year period based on the children's life expectancy, and then take out the rest at the end of the 10-year period. Now, perhaps what adult children should consider after their parent IRA owner died and they were the beneficiary of the IRA, yes, they can wait 10 years to take out all or take out the bulk of that IRA and pay tax, but perhaps they should consider taking out roughly equal distributions. So, for example, if an IRA owner dies and that beneficiary is 40 years old, maybe they'll be in their prime earning years when they're 50. Why would an IRA beneficiary who's 40 wait until, and let's say they're inheriting a $1 million IRA, and yes, by the time that beneficiary 10 years later is 50, maybe that IRA is worth $2 million, which is fine. But then because they waited the 10 years, now that beneficiary is in the highest income tax bracket, where maybe they could have taken out maybe $100,000, or as it would have grown, $100,000, $110,000, $120,000 annual distributions over a 10-year period. Perhaps that would not have lumped that child into the top 37% income tax bracket. And so there is this income tax kind of play where sometimes it behooves adult children to take out more than they're required in order to keep the income, from creeping into the next income tax bracket. I know until now, or at least until the Secure Act, everything was defer. People, once they reach their required beginning date, they only take their required minimum distributions. Under the pre-Secure Act rules, when parents left IRAs to children, children could, if they wanted to, take distributions over their remaining life expectancy. So the required distributions were always very small. It has always been defer, take the minimum. Now it's different. Now, since with this 10-year rule, when children have to take whatever's there out after 10 years, if they let that sucker accumulate, grow and appreciate, they're likely to, be lumped into that 37% income tax bracket. So perhaps they should consider taking equal distributions during the 10-year period. Now, parents, if they want to, they can force this equal distribution by leaving the IRA to a conduit trust, and they can say, okay, well, I'm going to leave my IRA to a trust for my 40-year-old child because my 40-year-old child doesn't make good financial decisions, and maybe my 40-year-old child will spend it all immediately, or maybe they won't spend any of it and they'll just let it sit for 10 years, and then they'll take it out and have to pay 37% income tax on it because it's going to be so much. So you could force the kind of equal 10-year distributions by leaving your IRA to a trust that says, okay, 1 year after I die, I want my beneficiary to get 1/10 of the IRA amount. The next year, I want them to get 1/9 of what's left. The next year, I want them to get 1/8 of what's left. And that really kind of forces the beneficiary to get those distributions in 10 equal payments, never to creep into much higher income tax brackets. So there's that. All right. Now, if you're a beneficiary, if you're a child who's a beneficiary of a Roth IRA, there's really kind of a no-brainer. Let that thing sit for 10 years, because if you're the beneficiary of a Roth IRA, you're somebody died, and by the way, earlier I talked about if an IRA owner dies before or after their required beginning date, it affects whether the child has to take required distributions during that 10-year period. But if you're the beneficiary of a Roth IRA, a Roth IRA owner is always deemed to have died prior to their required beginning date. So if you are the beneficiary of a Roth IRA, and let's say your parent died with $1 million IRA, if you can do it, let it sit for 10 more years, because you will be required to take it out once the 10 years is up. But now, it may have grown from $1 million to $2 million over that 10-year period. And now you're getting that entire $2 million completely income tax free. So if you are a beneficiary of a Roth IRA, it behooves you let that sucker sit for 10 years. And certainly don't take any out until you have to, because all that appreciation escapes income tax, which is cool. All right, now I'm going to shift gears, a different scenario. So what we just talked about, the typical married couple, one marriage, children of the one marriage, all good. Now we're going to get into that blended family situation. I used the Brady Bunch as an example in a live stream last week. You had Mike Brady and Carol Brady, and if you're around my age, you know the Brady Bunch story. Mike had 3 children. Mike had 3 sons. Carol had 3 daughters. They got married. Somebody informed me in the chat that they were both widowed. I didn't know whether Mike and Carol were divorced prior. Doesn't matter. So now let's say Mike Brady has his $3 million IRA. What do most people do with an IRA? Says, most people name their spouse as their primary beneficiary, but name your kids as your contingent beneficiary. So Mike says, sounds great. I'll name Carol as my primary beneficiary, but my kids are protected because they're named as the contingent beneficiaries. Well, really, your kids aren't protected, because when Mike dies and his wife Carol is the primary beneficiary, she gets to roll that over into an IRA that is in her name, and she gets to treat it as her own IRA. And guess who she's going to name as the beneficiaries of that IRA when she dies? She's going to name her 3 daughters. So Mike's 3 sons, really, they get the shaft, because they're going to wind up with 0. And Mike worked hard, I believe, as an architect for 40 years to build up his $3 million IRA. So blended families, it's a different set of circumstances. That spousal rollover can really mess things up. All right. So now the problem, if Mike has other assets, Mike has his 3 boys, Carol has his 3 girls. Let's say let's keep it simple. Mike has a brokerage account that's not an IRA, or he has $3 million of cash in banks and checking and savings and CDs. very common for Mike to say, I'm going to leave that in a trust for my spouse. And then when my spouse dies, what's left of those trust assets will go to my kids. That's a really common scenario, but really difficult to do that with an IRA, because if Mike leaves his $3 million IRA to a trust for Carol, and that trust says when Carol dies, what's left in that trust goes back to Mike's 3 children. That sounds like that would work. But the problem is, after Mike dies, Carol's going to be required to take her required minimum distributions. That trust might be depleted by the time, if Carol lives long enough. And so Mike's children aren't going to wind up with anything. So it doesn't work out too well. Oftentimes, if an IRA owner leaves their traditional IRA to a trust for their spouse, but when their spouse later dies, any trust assets revert back to the children of the first spouse to die, because often required minimum distributions require that trust be depleted. Now, with the Roth, it's a different story. You can do that, but not necessarily with traditional IRAs. So if you're in a blended family situation like the Brady Bunch was, maybe if Mike has a $3 million IRA, maybe he says to himself, I think what I'll do is I'll list Carol as a 40% primary beneficiary on my IRA. And if I die with a $3 million IRA, she can roll that 3 million times 40%, $1.2 million. She can roll that $1.2 million into an IRA in her name. Yes, I realize she could leave that to her children when she dies, but the other 60% of my IRA, the other $1.8 million, I'm going to leave that 20% to each of my 3 children. So I know that when I die, they're going to get something. And maybe that works for Mike because he's taken care of his wife, Carol, with part of his IRA, and he's taken care of his kids with part of his IRA. Yes, the part that goes to his kids, they'll have to, take it out of their inherited IRA and pay tax within 10 years after Mike dies, but that's okay. They're going to get some money. So now, also perhaps Mike, because if Mike leaves his traditional IRA to an accumulation trust for Carol and then Mike's kids, then those distributions that are required, they're going to accumulate in the trust, and they're going to, the trust is going to pay 37% income tax on all the trust income that exceeds, I think it's $15,000 in a year. So again, if you're in a blended family situation and you want to leave things to a trust for your spouse, but have those assets come back to your kids when you pass away, you may want to now start looking at converting those assets to that traditional IRA to a Roth IRA, so you can leave those assets to an accumulation trust where no income tax is paid on those Roth distributions. So just again, I'm not asking you to understand all the rules. Just be aware that there's some different circumstances that exist. Okay, now we'll talk about the single person who has minor children, or quite frankly, the married person who's going to name their spouse as their primary beneficiary and their minor children as their contingent beneficiaries. Minor children are an eligible designated beneficiary. So that means they get to use their life expectancy. But when minor children are eligible designated beneficiaries, they get to use their life expectancy until they're 21. But then they kind of lose the status as an eligible designated beneficiary. And then when they're 31, they've got to take all the money out. So anyway, you may want to use a conduit trust so that they're not eligible on their 18th birthday to take it all out and pay the tax, even though they don't have to take it out until they're 31. So, if a beneficiary dies and they're 20, and if they're intelligent and they're responsible, maybe they'll take out distributions annually until they're 31 to, avoid creeping into the bigger tax bracket. So there's some decisions to be made there. Okay. So now kind of, as I wind down these scenarios, the less and less applicable, I want to talk about one where either you're not married and you want to leave your IRA to a child or a person who just can't handle money, or you just don't want to give it to them in a lump sum for whatever reason. So we already know, and so this is the same as naming your spouse as the primary beneficiary, and this child or these children as contingent beneficiaries and your spouse predeceases you, then your children become the beneficiaries. But you feel like they're going to blow it. They might be on drugs, might be influenced by a spouse, but you feel like, if you just leave your IRA to them, maybe they'll wait 10 years, but it'll all be gone in 10 years. And so what you want to do there is, let's say you're 60, your child is 25, they're on drugs, and you feel like leaving anything to them might do more harm than good. So yes, you could name them as your beneficiary, and you pass away, they're 25, they could take it all right then, and they'd owe tax on it, and then they'd spend the rest. If they were a little bit responsible, they may take distributions over 10 years without, to avoid creeping into a higher income tax bracket, or they may just wait until 10 years up and then take it all out. But some people say, I wouldn't even want my 25-year-old getting in at 35. So that's where you have to leave things to an accumulation trust. You want them, you'd want them to get it maybe when they're 60, because you want them to, fend for themselves until they're 60. So you've got to leave it to an accumulation trust, maybe at age 35. Boy, it goes to the trust. And since the trust is accumulating those distributions, the trust is paying income tax at 37%. And then after that, the money gets invested. Maybe they get it when they're 60, but there's a lot of income tax paid. So if you're in that category where you don't like the fact that the children could get it within 10 years and they have to pay the tax, then again, you may want to consider, or mom or dad or mom and dad may want to go ahead and consider converting their traditional IRAs to Roth IRAs over a period of time, because paying income tax at the mom and dad level at maybe 22%, 24%, whatever the case may be, now may be a whole lot better, because you're going to be leaving it to an accumulation trust, maybe a whole lot better than the accumulation trust paying tax at 37%. So because if you convert it to a Roth and leave it to a trust that accumulates, then there's no 37% tax, because it's a Roth and that distribution is income tax free. And then, of course, after you die and after that Roth distribution generates income, that income will be subject to tax. Okay, so boy, that was a mouthful. One other couple of other kind of one-offs. If you're going to be leaving things to grandchildren, know that grandchildren don't qualify as eligible designated beneficiaries like children qualify as eligible designated beneficiaries. So those grandchildren, if they're beneficiaries, they got to, even if they're minors, they got that 10-year thing to worry about instead of minor children who get to wait until they're 31, because minor children are considered under the tax rules to be adults at 21. That's why they have until 31. All right. Now, if in the unlikely event you're single, you have beneficiaries who are disabled or chronically ill, they are eligible designated beneficiaries. After you pass away, they can use their life expectancy, and they're not subject to the 10-year rule. If your IRA is payable to your estate, which might be the case, which is the case if you name your estate as your beneficiary, and it might be the case if you have no beneficiary, then it may go to your estate, or based on the IRA contract, there may be some default rules that say it goes to your spouse. If you have a spouse, it goes to your kids. If you don't have a spouse but have kids, so we got to look at that. But if it is payable to your estate, there's a 5-year rule that applies, and all those assets are subject to the claims of your estate's creditors. So typically not a good idea to leave your IRA to your estate. Whole bunch of other special considerations that you just have to deal with them when they happen. Simultaneous deaths, when husband or wife or husband or IRA owner and beneficiary die at the same time. Sometimes when trusts are named as beneficiaries, they can be reformed after the death of the IRA owner, especially if they were created under the old stretch provisions. A lot involved with the Roth conversions, especially if you have a disabled child or you don't want to leave a big chunk to a beneficiary. Lot better income tax consequences. Typically, if you go ahead and convert to Roth now, you avoid a lot of these trust 37% income tax rates. Okay, a lot there. Let's head over to the chat, and really, what I'm going to leave you with now is just I went through a bunch of stuff and I was all over the place. But all I'm hoping to leave you with is, hey, boy, there's some special rules here. I've got a spouse, I've got children. Maybe I'm in a blended family situation. Maybe I have some children with some unique family circumstances. We better look into this IRA stuff, especially if the IRA is the primary financial asset that you own, like it is for so many Americans. So just know that there's rules, and as part of the estate plan, the idea is to just make informed decisions, not only in the planning stages now, but also ensure that the beneficiaries make informed decisions prior to signing a bunch of paperwork and taking possession of assets. Because once a beneficiary takes possession of those assets, those rights to do certain things that may save money are gone. Okay. Hey, everybody, a lot of haze out there. I like all the highs at the beginning. Keep them coming. Okay. And some of these I don't know the answer to. I'd have to kind of look up Roth IRAs from secondary school for kids only. I don't know if you're talking about Roth or 529 plans, maybe. Spouse is 11 years older, already subject to armed. I'm not. What happens if spouse passes before I am? Or anytime your spouse dies, you can roll it over into an IRA in your name. I hope that's answering the question. Yes, make sure you have beneficiaries on your accounts. Yep, and make sure it's consistent with your plan. Can you list trust? Yes, you can list a trust. Some people will say, I designate my spouse as my primary beneficiary, and I designate my revocable living trust as my contingent beneficiary, especially if you have some unique rules that would apply to your children, as opposed to just naming them as individual beneficiaries on your beneficiary designation form. So our rules that apply to beneficiaries, they can kind of look through that revocable living trust and use the individual's ages, even though they may be a beneficiary of a living trust subtrust. So you can, Pat, as long as it's done correctly. You're welcome. You're welcome. Larry, what happens if meets the legal definition, but then gets the condition reversed or it diminishes so they can work now? Good question. I don't want to answer it because I'd want to look at the rules. I think I saw a rule on that. That's a great question. What happens when IRA owner dies? Beneficiary is deemed disabled. They are an eligible designated beneficiary. But then while they're taking distributions over their life expectancy, they no longer become fit as disabled under the definition. Do they lose their status as an eligible designated beneficiary? That's a great question. Don't know the answer to it. Inherited IRAs have no, that's right. So that's why a trust with credit can shield them. Yeah. So yeah, that's another reason why the spouse often should do a spousal. If that surviving spouse doesn't treat it as an inherited IRA and treats it as a spousal rollover, they can treat it as their own. It maintains that creditor protection status. It's a good point there. Michael, still not sure what the RMD amount should be for my father's IRA. So you've already inherited from your father's IRA. It depends when he passed away. Was it before or after Secure Act? I've taken full withdrawal on all of them. Okay, well, there you go. So maybe it wasn't that big of an IRA where it made that big a difference whether you took the distribution or deferred them. So, but you eliminated the problem. So by taking a distribution. Thanks, investment management firm. You're welcome. Thank you. Good. Lillian, Frank, how do I prevent my children's money-hungry spouses from divorcing my children and run away with half of the money I intended for my kids? Good question. So we talk a lot about making a child's inheritance divorce-proof. I don't know if you're talking about IRA money there or just money in general. So we often set people's estate plans up so that it goes to a trust for the child. Maybe the child is the trustee of that trust, but maybe the child would be influenced by their spouse. So maybe the child shouldn't be the trustee of their own inheritance trust. Maybe there should be a co-trustee or other trustees. to prevent that spousal influence. So keeping those assets, inherited assets, whether it's an IRA or whether it's other assets, money, property, there's in the planning stages, you can do some things to ensure that your children's inheritance never gets mixed up or commingled with other assets they have with their spouse, so that if they get divorced, they keep their inheritance or they keep their trust, and then they have to split other assets they've acquired with their spouse. Good question. And there's some planning that kind of active planning that you can do. All right, let's see here. Okay, Chuck, call the broker. Yeah, financial institutions will typically calculate your required minimum distribution because they don't want to get stuck with you having to pay a big penalty for failing to take your required minimum distribution. By the way, which I believe the penalty has reduced from 50% to 25%. Okay, let's see here. The one is giving me 10% a year. Okay, there you go. How do you get 10%? I think what you're talking about is you're taking 10% of the IRA balance, Chuck. I think that DKS there is thinking that you're getting a 10% return, maybe a little lost in translation there. What do you do if you want to name a minor grandkids as IRA beneficiary? So you have to make a decision. Do you want it to be a conduit trust, which means they're going to get all the money within 10 years after you pass away? Or do you want it to be an accumulation trust where the trust will pay income tax at 37% on some of that money, but it'll be accumulated and they can get it over a period longer than 10 years after you pass away? Those are some of the decisions that you have to take into account. Okay, good one, guys. A complicated one, but a good one. Great questions, great comments. We'll have to do more. My thought is this was pretty broad. I want to narrow down these rules on distributions from IRAs and really dig deeper into some of the niches and just do it one at a time. But stay tuned for future live streams. We'll see you next time. Thanks, everybody. You guys are awesome, and we'll see you next time.